Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. I hate to do this, but I'm actually going to have to talk about forced reset triggers and wide open triggers again, or what we also called Operation Reticent Recall. But this time it's much different. It's not about the ATF being up to something even more nefarious than they've already conducted. No, this is actually about a lawsuit. And this lawsuit has a lot of teeth to it. It's a lawsuit that's meant to go completely after ATF's enforcement actions on forced reset and wide open triggers. And more importantly, for many of you who may have already surrendered or turned in these triggers, well, one of the remedies is for all those triggers to be returned to you. So today, let's spend a few minutes and let's talk about the case that's meant to destroy ATF's trigger trap. Okay, coming to you from Washington's nicest indoor range, of course, that being Security Gun Club, or right here in Woodinville, Washington. The case we're talking about today is a case called National Association of Gun Rights v. Garland. It's a case that's filed in the Northern District of Texas. It's the first time we've gotten to talk about this case, but listen, I've had a chance to read the pleadings. They're really well drafted. NAGR has done an excellent job here. There are other named plaintiffs. There are private citizens that they're representing. But this is an all-out frontal attack on what we called Operation Reticent Recall. Now, if we go back in our time machine and we just want a very quick replay of what happened, a couple of companies, Rare Breed developed a trigger called a forced reset trigger. Another company called Big Daddy developed a trigger called wide open trigger. Both really cool devices did definitely increase the rate of fire. ATF had apparently been okay with this to begin with, but then suddenly a couple years ago got a real beef about it. That ultimately led to them issuing cease and desist letters saying that these triggers, essentially standing alone, constituted a machine gun, ultimately raided these facilities, and then ultimately started sending nasty letters to all the end-use consumers, many of which I have had the pleasure of speaking to around the country when you received your nasty gram from the ATF. Now, many of you decided, oh, hell, I don't even want to deal with this crap, cut that trigger up or arranged for a surrender of that trigger. So many of you, and I do mean thousands and thousands of you, are been placed out of personal property at your expense. Let's remember that, because this was at your expense. None of you have been compensated for the trigger that the federal government took from you. Okay, so there are two reasons why I feel really confident about this lawsuit. Number one is the statutory framework by which it's being argued. Because the applicable statute, that is the federal definition of a machine gun, well, this is how it used to read. Any weapons which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. The term shall also include the frame or receiver of any such weapon, any part designed and intended solely and exclusively, or combination of parts designed and intended for use in converting a weapon into a machine gun, and any combination of parts from which a machine gun can be assembled if such parts are in possession or under control of a person. And of course, the phrase that we're going to have you focus on here is by a single function of the trigger. Now, as we know, as ATF loves to do, they love to say, you know, this law seems really kind of vague, and so we're going to add some extra language to it, you know, just to help everybody further understand. Typically, they do that to advance a political agenda, because many of these laws have stood the test of time. We clearly know what they mean. What ATF did, though, through the Code of Federal Regulations, is try to add additional definitions to machine gun, which included the following language. For purposes of this definition, the term automatically, as it modifies shoots, is designed to shoot or can be readily restored to shoot, means functioning as the result of a self-acting or self-regulating mechanism that allows the firing of multiple rounds through a single function of the trigger. And a single function of the trigger means a single pull of the trigger and analogous motions. The term machine gun includes a bump stock type device, a device that allows a semi-automatic firearm to shoot more than one shot with a single pull of the trigger by harnessing the recoil energy of the semi-automatic firearm to which it is affixed, so that the trigger resets and continues firing without additional physical manipulation of the trigger by the shooter. Now, that's a big, gigantic word salad that was designed to actually do away with bump stocks. But unlike how we define automatic weapons out here in the People's Republic of Washington, one of the things you'll notice is that the rate of fire, that is how many rounds can be fired in a 5-second interval or anything like that, At no point is that a component of the federal definition, and that is important for where we're about to go. You see, because this whole technology and what constitutes a single function of the trigger, well, that's already been litigated, and that has been litigated in the matter of Cargill v. Garland. Now, this was a challenge to ATF's rather abrupt banning of bump stocks after a horrific mass shooting. And we've been critical of the way that was done because there was clearly the political clout by which then President Trump could have easily had Congress pass that ban. Now, it would have been certainly subject to certain constitutional challenges, but the manner in which this ban was actually effectuated, that is just turning the ATF loose and saying, hey, why don't you go out and write some new laws and get rid of this thing? Well, that's been the problem for the bump stock ban and why the plaintiffs have prevailed in the matter of Cargill v. Garland. As plaintiffs' counsel here, the NAGR, points out in their pleadings, there is significant holdings already from the circuit court that would oversee this court that basically says you're going to have to reach the same conclusion as it relates to this technology. The pleadings state, in Cargill v. Garland, the Fifth Circuit held that ATF's 2018 bump stock rule, which expanded the meaning of the term machine gun, violated the Administrative Procedure Act by exceeding the agency's statutory authority. In doing so, the Cargill court examined the statutory text defining machine gun and concluded that the statutory term single function of the trigger is not synonymous with a single pull of the trigger. The problem with ATF's interpretation is that it is based on words that do not exist in the statute. The statute uses single function of the trigger, not single function of the shooter's trigger finger. The Cargill court stated, we are obliged to conclude that the statutory definition of machine gun unambiguously turns on the movement of the trigger and not the trigger finger. Instead, the statute requires that a machine gun be capable of firing automatically once the trigger performs a single function. And if you really want to break it down into high school grammar and English, plaintiffs' counsel was quick to point out the prepositional phrase of the statutory definition defined the firing's process requirements from a mechanical perspective. The process must occur by a single function, and the single act must be by the trigger. In short, there is no mention of a shooter. The grammatical structure continuously points the reader back to the mechanics of the firearm. The statute does not care what human input is required to activate the trigger. It cares only whether more than one shot is fired each time the trigger acts. And in their complaint, plaintiffs' counsel also points out Cargill is binding precedent on this court. Cargill unambiguously rejected the same reasoning defendants purport to use in classifying forced reset triggers as machine guns. In the FATD reports referenced above and the open letter, the ATF explicitly claims that FRTs are machine guns because they may enable a user to fire multiple rounds with a single continuous pull of the trigger. This interpretation is foreclosed by Cargill. Defendants have not and cannot allege that FRTs allow users to fire multiple rounds by a single function of the trigger. An FRT resets after every round is fired, and the trigger must engage in a separate function of releasing the hammer for each and every round fired. The defendant's interpretation of the law and their specific actions to threaten and potentially initiate enforcement actions against plaintiffs are thus arbitrary, capricious, and otherwise contrary to law. Now, what are the remedies? Because for every action we have to have a remedy. What do we mean by that? What is it that they want the court to do? Well, there's multiple things the court they want to do. Yes, injunctive relief is one of them. A restraining order against the government from enforcing this rule, and any injunctive relief to keep the rule from being enforced. They also want declaratory judgment. They want the court to declare that this rule is unconstitutional on its face and throw it out on its ass. But here's what else they're asking, because one of the things that the plaintiffs ask for, an order requiring that all FRTs seized by or surrendered to the defendants be returned to their rightful owners, or, if destroyed, the rightful owners be compensated for the value of their lost property. And that could get a little expensive for your Bureau Alcohol and Tobacco and Firearms, but that's okay. They're just going to take it out of your tax dollars anyways. The case, once again, is National Association for Gun Rights v. Garland. We're going to put a link not only for the complaint that we talked about here too, but we're going to put a link down below for NAGR. If you're not a member, you ought to think about it. If you want to show them some love, I think you should. They are out there in the trenches fighting like hell to preserve your inalienable rights. Listen, if you got any other questions about this case or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is right down there in the description box. In the meantime, I do want you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.